introduce you, and then we can go ahead. I have also live streamed the program, the event today, on my Facebook page.
Okay, great.
Right.
Wonderful.
Okay. So, good evening, all my dear friends in India, and good morning to all my friends, professors and lawyers in the United States. I'm Nachiketa Mittal. My friends in India already know me. Some of my friends in the United States who must probably be watching the program. Could some of them, I have met them probably earlier. So, my regards to all of you. Uh, my dear friends, as you all know, that we started as the journey of the virtual law school in April this year. And Ben, it's my honor to tell you the story of the virtual law school in a very short summary, so that and then on that you can then build upon your entire presentation after that, which is a different set of a topic for the day. So we started our journey in April earlier this year during the national lockdown, when India was undergoing a national lockdown by virtue of the crisis of COVID-19. And that is the time when I took a break from the institutional teaching, as you know that I was teaching in different law schools in India. And we have started teaching mainly a lot of law students across the country pro bono. So we were blessed to get support from the senior members of the judiciary, bar, bench, legal academia. So they were, judges, former judges of the Supreme Court, like Honorable Justice Sikri, Honorable Justice Kurian Joseph, then senior counsels from the Supreme Court, Mr. Siddharth Luthra, and also, corporate senior counsel, Mr. Rajiv Luthra, and some of the vice chancellors and professors of law who supported us in the inauguration of the virtual law school, where we started a journey teaching around 600 law students from across the country completely pro bono. And I'm happy to tell you we could do that for 6 weeks, for 6 days a week, and teaching around 10 subjects with the help of several lawyers, judges, and law professors. And after that, we moved to another edition of the virtual law school, subsidizing the law classes substantially and charging very low, which is called as the low bono edition. And it's now as I'm speaking to you, we are closing with the 16th week of law teaching that we started in the second phase from 27th of June, and in which we are teaching 20 law subjects, the core law subjects, which are any law school actually teaches as per the curriculum also, and established norms of the Bar Council of India. So in that, again, we could get support from a lot of judges, lawyers, and professors and the legal academia. And we have been going ahead in this journey. And this has been a part of that virtual law school that we have been conducting the global legal approaches and development talk. The idea was that alongside the teaching, we could bring in experts from various parts of the country and also overseas, who have been doing very distinguished work in the field of law, and so that our students can be exposed to those kinds of experts. For example, now we are happy to host you today, who can speak on diverse kinds of legal developments in one or the other field of law. And in that, for example, recently we hosted Honorable Mr. Justice Michael Kirby from Australia, who is also going to speak once again on October 31st. Then we could also host some of the senior counsels from the Supreme Court, Mr. Kapil Sibal, Dr. Abhishek Singhvi, Mr. Salman Khurshid, Mr. Prashant Bhushan, Mr. Yatindra Singh, and also some of the professors of law and the vice chancellors, like Professor Shanta Kumar from Gujarat National Law University, where I'm currently located in the state of Gujarat. So this has been the journey so far, Ben. And today I'm very happy to welcome you personally as a friend, and also as leading the virtual law school as a professor, for delivering the talk on one of the very relevant and subject matter which is contemporary, which we all are grappling with in terms of newer challenges, which is online dispute resolution in times of pandemic, discovering new normal of dispute settlement. And to tell all my dear audience, my dear friends, students and lawyers in India and also in the United States, I'm happy to introduce to all of you to my dear friend Ben Davis. So Professor Benjamin Davis is a graduate of Harvard College for BA and Harvard Law School for JD. And also, Professor Ben Davis went to Harvard Business School, where Ben was also articles editor of Harvard International Law Journal. Ben has also taught in the areas of contracts law, commercial law, alternative dispute resolution, arbitration, public international law, international business transactions, and 3L extended bar preparation. When I remember this about your teaching, I can, recall that our classes when I could also attend your class of contract law, you remember? Right?
Yeah, absolutely.
In November 2018 in Toledo. And since, we have been jointly also been teaching few things, and I could teach some of the arbitration law classes in your law school too.
Yes,
So,
absolutely.
right. Ben, it's also very important to host you today for the reason of your diverse experience. My dear friends, Professor Ben Davis has been a former chair of American Bar Association section of dispute resolution and a former member of ABA Standing Committee on Law and National Security. Ben has given numerous presentations and speeches around the world. He is a contributing editor at Jurist. He has published dozens of articles on the topics related to international and domestic arbitration, online and offline dispute resolution, and international law. So this has been the brief profile of Professor Ben Davis, our guest for the day, which I've also shared across in different emails and WhatsApp groups on social media for our friends in India and law students to get to know you beforehand while we were preparing for the entire event. So on that note, Ben, I welcome you once again. So, can you hear me?
I hear you now. Yeah.
Okay, yeah. So we all are
Okay.
waiting to listen to you, your insights on this entire gamut of online virtual courts, mediations, arbitrations, how online they are being done today, what could be the future of them. Even in India, to tell you, we have been holding virtual courts from the Supreme Court to all the courts down below, and all the mediation, arbitration, everything has been going online. But from your experience, it is going to add much more value for the legal scholars to look at it. So over to you.
Well, thank you very much. I'm greatly appreciated. I wondered, did we say that I should speak for about 20 minutes? How much time do you want me to speak?
Right. So what we planned was that you can speak for like 35, 40 minutes, followed by
Okay.
Q&A,
Okay.
if you're good on time with that.
That's perfectly great. Okay, great. Well, first of all, I'd like to thank you, Nashikita, Nashi, Dr. Mital, my good friend. We've known each other for quite some time. I have been honored to have you come here to Toledo and speak to our students about the arbitration topics, and to just hang out with you when you were here. And one of the sad things about this pandemic is that this kind of opportunity to see each other has been basically cut off for all of us around the world. And so this is the best we can do to make sure we maintain the friendships, maintain the contacts. Secondly, I am very excited about what you are doing with the development of this virtual law school and bringing together all these different parts of the legal community there in India on this adventure, which is basically what we could call a COVID adventure, if you say, since April, right? And that's that kind of flexibility and adaptability in this reality is really quite kind of a metaphor for the issue of the topics that I'm going to be addressing now. So just so that we don't lose sight of the COVID-19 pandemic, I just took a look on site to see the total numbers in the world right now. And the total numbers in the world right now of people that they know of that have been infected are 40 million people. And of that 40 million, there are the total numbers I just saw, a little bit over 1 million people who have died. And the curves are just showing this rise, almost a geometric rise in these things. And then I looked at India with its 1.4 million people population and saw that you were a little under 8 million cases infected and about 115,000 people who have died as of yesterday. Here in the United States, where we're only 330 million, we are over 8 million infected, and 220,000 people have died. So it's, you think of each of those persons and each of their families and the loss of the ones who've died, but also the people who will have these pre-existing conditions potentially for the rest of their lives. And we really see that it is a very, 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 very difficult moment for all of us all over the world. And I hope that everyone is, what we call it, wearing their masks, doing the social distancing, washing their hands often, because I actually have a T-shirt on, which I will now take off. This is my phrase with regards to the corona, which is that everybody say, corona don't play. So this is hitting all of us at the same time. And we have a lot of people who make different kinds of arguments about this, that, and the other with regards to whether it's real or not. And it is terribly real. And so it's had a tremendous effect, as you talked about in India, on the legal profession, on courts. Number of courts had just shut down. At the Supreme Court of the United States, the oral arguments now are being done over the phone, virtually. I was in the Supreme Court in January, watching a hearing in the courtroom, and literally 2 months later, all of that disappears. You have the tension between criminal and civil cases in the local court or up to the the district court level, the lowest level, or appeals court. And we've talked with judges here in Ohio. We have the jury trial for criminal cases, but we have them in civil too. And here's the issue of how you do a jury trial in a virtual environment. If you're going to do it in the courtroom, how are you going to do social distancing so that people don't, you have to choose the jurors, of course, how you do that process. Courtrooms would have sort of a gallery where people could sit. All of a sudden, it's supposed to be a public courtroom, but you can't have anybody sitting there because of this risk. And you need those seats for people to be able to be spaced enough. We used to have over on the side, we sort of this jury area with the 12 seats sitting next to each other. It doesn't work anymore. You can have maybe 2 people in that space that you used to have 12. So how are you going to have the jury listen? Then there's the question of the lawyers and their clients. As you know, lawyers, when they represent a client, especially in a criminal matter, want to be standing next to their client. So because the client doesn't know the law and what the implications are of anything that they say. Well, how does a lawyer stand next to their client when they're socially distancing in 6 feet? I've talked to some of the judges here in Toledo and about doing online court. And, we're at least when I was talking to them in April, they were thinking about it, trying to figure out how to do it because they were not familiar with the technologies that potentially could be done. And there is our constitutional concern about the, due process, all those type of things. Would a virtual court be the same? Or how about confronting your accuser? Can you confront your accuser through a screen? Now, there's a long history of using technology mainly, I think, for cost purposes. For example, in criminal cases where someone was being held, it used to cost a lot of money to bring them down to the courthouse for their arraignment from wherever they're being held. And so what you would have now is that they'll have some kind of feed to the courtroom from out at the prison, and the person will go in the room there, and their lawyer might be with them there, or the lawyer might be in the court. This is the way, and this was done so as basically avoiding having to have people being brought down in cars and all that, and all the costs related to doing that. And that's worked pretty well in many places. So technology comes in to help solve problems. That being said, I understand that some judges, if it was a case where a person was accused of murder, they wanted the person to be in the courtroom so they could see them in the courtroom like that. You know, that was so that's all about the psychological part of this, if I could say. So that's over in the courts. Now let's go over to dispute settlement, what we usually call negotiation, mediation, arbitration. For negotiation, I think lawyers have adapted very quickly, representing their clients and business people and others with regards to negotiation of what's going on. I mean, a lot of times negotiations have been done just by email. And so that's not a complicated, we're used to using email now. Maybe with our little devices we could actually see each other walking down the street negotiating or something like that. We've gotten comfortable with all of that. So say you have this negotiation and you have somebody, type up online a contract for a machine. Great. All this is going on online. And now you have to sign it. Do you have to have a physical signature? Is an electronic signature enough? Well, what is the law potentially at the place where any kind of issue could arise? What does it say? Is an electronic signature sufficient where the person is signing? Is the electronic signature sufficient for purposes of some place of arbitration and law that's chosen in a contract with regards to proof, this kind of issue? Now, we've gotten used to doing things this way, especially in the pandemic, because we have to. But, should you have a written signed one that gets sent also to the electronic one that is exchanged to make sure that everyone has a physical signature as well as the electronic signature, so you avoid the issue in a certain way. Here is the contract physical, here is the contract electronic. There we go. Whatever the state of the particular legal regime you're in, physical usually works and the electronic might work. And this gets to the UNCITRAL model law and electronic commerce issues and trying to have all those writing requirements in the law be electronified. And that's something that's been going on in all of our countries. But that part of online negotiation with that thought of how am I going to maintain the proof of the actual contract is something that you have to think about. And that extra step of getting it actually physically signed in this time of evolution, I'm just suggesting, may be the prudent way to go until it becomes the natural way, until we're into, no one ever signs a contract physically anymore. We get to that kind of evolution. But here's another thing, all that negotiation history that we just talked about, or how about all the discussions about performance? Are they being done on Zoom? Are they being done on WebEx? Are they being done on some other kind of forum? Are they, like you have folders for different subjects in your computer? All of this electronic evidence that we have now, how is that maintained for purposes afterward? What if one party making the machine says I made it fine, the other party says it didn't get done fine in a heated discussion on Zoom here? And you said this and I said that, and all, you can see all that animosity. Or you didn't pay me, I sent an electronic payment through this thing. You see, all of this is evidence, right? How do you, you're the lawyer who gets contacted after this problem arises, and you've got to create the case. So you've got to get the file, but the file is not a physical file, something like this, right? It's all in this machine of somebody somewhere, and maybe many machines. That's the dilemma of getting even to the next step, which is you organize what your issues are, and now you're ready to go forward and maybe have a mediation. Okay, now we can talk about institutions that do mediation or not, right? But the first step I'm saying is this task that we've been getting adapted to. And think of the people who have paper files as well as electronic files up till the pandemic, and now they're all electronic. So what they used to do on paper, they have to been forced into electronic. Now, there is one thing that's very good about the electronic is that you can't get a virus from it. There you go. Well, you might get one of those electronic viruses, but it's one of the benefits in a way that the issues of this risk of COVID aren't there. So now you move to the issue of mediation. And I was actually talking the other day when I was getting my car repaired with a bankruptcy judge here in Toledo who did a mediation for another judge in another part of Ohio, in eastern Ohio, and talked about her experience doing that. So in mediation, you're trying to help the parties get to a settlement. It could be, you could be facilitating, or you could be kind of more directive in your mediation strategies as the human being who is in this space. But and one part of mediation, this classic structures, is you sort of have an opening meeting of everybody, an open meeting with all the parties. They may tell their stories, and then each of them will go caucus in separate rooms themselves. And then the mediator will kind of go back and forth between the parties, trying to see what the issues are, fine tune the issues, and hopefully trying to find a space where there's agreement, and then bring everybody back together for the agreement, which couldn't be memorialized in some kind of a contract, right? Or settlement agreement, we could call it. Well, no one can get together anymore. So one of the things that happens is it's very important that that person in that mediator role try to think through all the things that they do in a physical meeting with people that are sort of natural in that setting. Remember shaking hands or saying, hello, how are you? All that. How do you do the greeting online to people? Like right now, I am looking at you in the eye as I talk to you, but I believe that what I should be doing is looking at the actual camera talking to you, right? Now I look like I'm talking to you, right? But in fact, down here is where I feel like I'm talking to you. You see what I'm saying? This is the kind of crazy issue that we run into, but that you have to think of. If I want to have people think that I am really listening to them, just because I lean forward and I look at you, is that really me listening to you, or is it me looking at something else? But if I do this, oh, he is listening to me. He is really listening. You see what I'm saying? You have to think about that. Or one of the things that you may do is you have to explain what you're doing in the technology to the people who are there so that they understand that when I'm looking this way, I'm not looking away from you or not listening, but I'm just looking at you in the eye. So I might be saying, for example, counsel for claimant, I'd be looking over here. Counsel for respondent, I'm looking over here at this other person. I'm not looking at them like this, and we have sort of a test of looking at each other in the eye. You see what I'm saying? These are all signals that in the physical world, very easy, right? The other thing is that when we have interactions in the physical world, we do micro pauses. things like that. Might be somebody will turn a page in a book, or the person will grab their water, and all these things that we do that are actually sort of pauses that we do naturally. They may be a little more complicated. Another one, and in the to see them as pauses in this virtual space. And so it might be worthwhile as part of the opening statement or presentation to highlight these kinds of physical things. I know a particular person who their face, their eyebrow, when they get tired, goes up like this. Or I can't do it myself, but it goes up like this. And so all of a sudden, their face looks like they're being very skeptical about what the person they're talking to is looking at. It's got nothing to do with what the person is saying to them. It's just that they have this eyebrow and they literally have to push it back down, right? Well, that has to be explained so that the person who is on the other side, the counsel on the other side, would not to get the false impression that the mediator was being too skeptical about anything they were saying. It had nothing to do with them. I mean, there's a million of these things that you have to think about and then articulate with your the people in the room. And also, what it does is for the people in the room, they can articulate their particular things. The counsel for claimant, counsel for respondent, the parties, the actual parties themselves, they can just say a little bit sort of ground rules. Please understand that what I am doing is this thing. And so that everyone understands what is the goal here? You're getting everyone comfortable. So now let's talk just briefly about online mediation and breakout rooms. Yes, if there's technology, you can have breakout rooms, which will have one party on one side and the other party in another breakout room, all that stuff. But, you know, in the real world, when you come in as the mediator, you knock on the door saying, I'm coming in. Well, how do you knock on a door into a breakout room? It sounds pretty obvious, but there you have to find the signals that tell people, this is how I'm coming in, okay? So that the people in that breakout room will know, okay, the mediator is going to be with us. We stop our conversation. And here's another thing. When you finish discussing with the people in the breakout room, in the caucus there, you walk out the door. You close the door. How do you let people know you walked out of the door so that they can go back to being alone? These are the kinds of things that are what we do so normally in the physical world. But and I'm just taking the mediation session now, and I'll go to arbitration in a second. But these are things that are so normal in the physical world that come into organizing the virtual space so that those skills that we talk about from with technology, those skills that we talk about in mediation can be used. I like to say that you want to make the technology work so that really it becomes invisible. Like right now, at least to me, I feel like I'm in a conversation with you, one-on-one. And that's the way I relate to this experience, Nashkita. At the same time, I know that there may be any number of people who are watching us doing this interaction, right? So I have to think of people I don't see that are out there. One of the things that I like is to go to what they call the gallery option. So if you're making a speech, then you're doing a presentation, or even in these, in that everyone in the same room vision, you have the gallery of all the people who are there. And so you have the sense of that, all these are choices that we make, and their advantages and disadvantages, and the technology as it is permits us to do this or that with this possibility or this unfortunate disadvantage. And so we have to sort all these things out. But that's mediation, which is, again, a non-adjudicatory process. And remember, I started out with the courts, which is the adjudicatory process. So now let's look to another kind of dispute resolution, arbitration. So we get to arbitration, and I'm going to speak particularly to international arbitration. We've talked about a contract for a machine, right? There was an arbitration clause in it, okay? The arbitration clause, let's say, has an institution, the International Chamber of Commerce or Singapore or the center in India. I'm just, they choose a set of rules of an institution to run their arbitration. I could speak about the ad hoc sort of UNCITRAL rules too. Okay, that's fine. But still, I just want to start with the institution side because you're picking an institution's rules. Well, one of the things about that arbitration clause would be, how do you start the arbitration under that institution's rules? For example, I make all those issues we talked about, evidence and all that, they form it into a notice of arbitration, or sometimes called a request for arbitration. What are the rules of that institution and what that's supposed to contain? How is that stuff communicated to the respondent in the case? Is it done by the institution? Is it done by the claimant, sending both to the institution and to the respondent? And the sending part is, how is it done? Is it permitted for it to be done by, I guess, email, virtually? Even if it is permitted to do it virtually, is it prudent to do it virtually for issues of, was there proof of notice of the arbitration having been commenced? Or is it better to have both the electronic and a physical, courier, or even by hand delivery with proof of receipt, or even the old famous little cards from the post office that we used to get when I worked at the ICC, that you sent it by the official mail and got the registered return receipt as proof that the other side had gotten notice, because the basic rules of due process or principles of natural justice always start with notice, right? And then the second part is the opportunity to be heard. And so if the arbitral institution's rules become part of the contract by being incorporated by reference, are they prepared to address this kind of environment of these electronic or having to use technology? So I've spoken about the request, I've spoken about the arbitration institution starting up, and now we go and we have on the other side the respondent. Again, how does the respondent bring together all of its information and all that, and do the same thing maybe with counterclaims? How does it communicate to make sure? Does it do both ways, i.e., on through the institution, electronically as well as physically, just to make sure? Next step that we have, of course, is, or maybe it started at that point, is you've got to get an arbitral tribunal. Well, we're talking about a machine. Somebody who knows about the machine, right? But they've got to know something about the law. What law have we chosen? Let's say we've taken Indian law. Well, we want somebody who knows Indian law. No, that it might be USA law that applies. Oh, well, we need somebody who can be comfortable with USA law. Yes, but is law in Gujarat in India different from the law in Toledo in the United States under Ohio law? Maybe we need somebody who has, you see what I'm talking about? Okay, we found somebody who can do these things, but here's another question. Have they ever done an arbitration? Are they going to be using Indian procedure? Are they going to be using U.S. procedure for doing like they were in front of a court where none of the court's rules apply? So have they ever done an arbitration before? Or have they some experience with arbitration and all that? Oh, great. We have found the perfect person. He is from Gujarat. He speaks perfectly all the languages that'll be in this case. He knows all the laws, and he is available. But he doesn't have a computer. He doesn't believe in computers. He has a cell phone. It's good, but can he handle it? Or can she handle this kind of environment? Are they going to have to learn how to do the things that we've become comfortable to? And let's say the person is very distinguished too, of course. And I'm not saying anything against it, and I'm maybe kind of making a hypothetical that's extreme, right? I understand. But I'm raising the issue of the level of comfort the person has with technology. For example, you might have someone who is absolutely perfect in the physical world, but they get very distressed when something doesn't go right on their computer. You may not know that in the physical world, but all of a sudden you see them and they lose credibility as an arbitrator in that setting because of the way that they act. They get kind of nervous. They have to call their wife or husband over to, can you fix the thing? These are all, you think I'm joking here, but I'm very serious about that issue of the level of comfort. And now here's another thing. So you find maybe somebody who is good and they've got the technology. Here's the thing that they may do is they may not have just the one screen like the one we have here. They'll have 3 screens. One screen with all the claimants' information over here, one screen with all the respondents' information over here, and the actual hearing going forward in the room in front of them, on the screen in front of them. That takes a certain level of skill to be able to do that. Now, is that person as great as the distinguished person we just talked about? Maybe not, but the combination of their ability to deal in this electronic environment with also understanding of the law and all that we talked about and how evidence and how to do a procedure may make that person really much better for the kinds of pandemic, post-pandemic online arbitration situations that can arise. So that we're just at the arbitral tribunal trying to figure this out. What if you need interim measures before the tribunal's in place? They got to go to a court. Again, that's a whole nother, we come back to that virtual court issue that we talk. Can I get preservation of evidence order from this court here, please, to help assist the arbitration? All these things, you're seeing the flow of this electronic stuff around as part of this arbitration that, we would have thought of it sort of more of physical, but I see it as almost like, electrons shooting in different directions that together form this online arbitration experience, even though we were all sitting separately in the worlds. So let's say we have the tribunal in place, the case is going to start. All right. A lot of times you hear about people talk about bundles of documents. We will have a bundle of documents that the claimant and respondent will provide to the arbitrators or so. And arbitrators, one of the things for the parties is how do you organize your presentation for it to be electronic? I mean, for example, numbering your exhibits. You can have a folder, like you have your folder there with exhibit 1, 2, 3, 4, 5, 6, 7, up down to 500 in a way that's much different than giving a file in front, you see? But you have to think about all those things. And also, as you do your argument or your pleading, you have to think, I was talking with you have to think about how to do the argument. Please turn to document 37 as opposed, I was talking with a person who just recently did an arbitration named Catherine Simpson, talking about, helping people to learn how to organize for the online environment arbitration. Or for people to think it through very much carefully what the difference is between the physical and the actual online position, the online arbitration. So we have the issues of the submissions on both sides. Experts are another dimension, how you get the experts involved. Witnesses. An interesting point that Catherine Simpson pointed out to me is that one of the worries that people have is that we are here together, okay? And you are, say, asking me questions about something in some case, and director cross-examination or something like that, how do you know that there's not somebody next to me over here somewhere who is whispering or putting up little signs or things like that telling me this is what I should answer, right? I mean, how can you know, right? Or, my little cell phone here that's right up underneath, and it's got these little things that somebody's passing to me. Yeah. I mean, you see we can have all of that anxiety, right? But she made a point to me that I thought was really good. We have witness statements that sometimes happen as direct in arbitration to save time. Who helped write the witness statement for that witness? Usually the lawyers help them, the lawyers on the side presenting them will help with the drafting of that witness statement. I'm not saying they're going to make it inaccurate or anything. I'm just saying that they're going to be careful in drafting. So who helps them? It depends on the system, but the person may also have their own lawyer help them draft. So this is the direct exam, is this document. So on a piece of paper, you don't see those people. You just see this and the person saying, this is my statement, right? In the virtual environment, now we sort of worry about what's going on outside. And I think that it gets a little more complicated, I think, when we talk to criminal cases in court and all that kind of stuff. But if we stay in this online arbitration setting, is that worry that we're having really something to worry about? What if there is somebody over there that is, instead of my cat, that is actually, somebody whispering something to me? Or, I mean, what could happen in physical space? Somebody could have their cell phone there and, they could say, excuse me, I have to go to the bathroom, and they go out to the bathroom and they, look at the phone and come back in and say, there's a million ways people can play, right? So all I'm just trying to say is that I'm not so convinced that, or I've been convinced that it's not as complicated as people say for witnesses. But here's another thing, which is, if you have a three-member arbitral tribunal, are they all in the same place? Like they would be next to you, and you three together would be talking to me? Or would you be three different boxes in three different places in the world? And how does that affect the interaction between the members of the arbitral tribunal as they ask questions to a party's counsel, or they listen to a witness and all that? Again, we get back to the level of comfort with being in the technology of the person who is in that role. I asked you at the beginning of this if I could share my screen. And we talked about the technology issue related to that with regards to the recording issue, which is the recording issue in this, these are, the folks at WebEx made a choice, which was, if you share a screen and do a record, it will not take the share screen. That dictates how this space happens. In time, I bet you they will say, well, of course we should be able to record what somebody shares on their screen as part of the whole thing, wherever it is. But does that mean that they now have to go to that machine of that person and, and all these other issues that are way more complicated than I will ever understand? But they have to think this through as they evolve their technologies, you see? The other thing about sharing the screen is that when an arbitrator is in the physical space, they have their stuff in front of them, but, they're not really sharing it with the parties. Well, now the arbitrator shares the screen, and there's all this stuff that's on that screen that I can quickly take my camera and click and see what they've noted and all that stuff. You might have to be very careful about it. Maybe, have somebody have sort of a neutral set of documents that when they talk about document 22, that person will put that up as the shared screen without any of the notes of the arbitrator or anything on it. So it doesn't give away the part of the arbitrator's deliberation. These are some of the other things that you have to think about. I talked about the arbitrator's deliberation. Again, are they together? Are they separately doing it? I think there's a lot of deliberations that go on in international arbitration already by email, by phone, and all that. So that's not too unusual. But then we get to the final award. That's let's say the award that the arbitrators are doing, and then there's the question of signature again, getting the signatures, the date of the award, the place of the award, all those kinds of things, and the physical version of it, and the electronic version. Is it notified out by electronically? Is that going to be proof again of receipt? And that it's important because that can start dates for when you want to attack the award or set it aside and all that from the date of receipt. Or, I mean, I am personally of the view that, again, you can have the electronic notification, but you also should have a physically written, signed by Joe Schmo, Jane Simpson, Nashikita Mittal, that is sent to each of the parties and kept by the institution, so that we have the old physical proof that they got it. Now somebody is not happy with the award. They want it set aside. We're back to the virtual court again. How is that going to happen? And all the issues that happen for attacking an award, right? We're back to that again. Which court in the world? Let's say the court you go to is a court for enforcement of the award. Well, how friendly are they to electronic online arbitration awards? Have they ever seen them before? Does the local law or public policy have certain restrictions that are sufficiently important that they might be considered international public policy in that particular country about what principles of natural justice, due process are? You actually should have been thinking about that all the way at the beginning. But we just walked it through like this to see how you're going to do everything along the way to make sure that at that moment, that court will say, fine, the award is good, it's going to be enforced. But again, you see how that happens. So now, what I've tried to just say is we're talking about different processes that we are all aware of, all comfortable with. We are all humans. That's the one thing. Okay, all the technology is here, but we have to remember we are. Part of this is a human process, right? And then we have this technological overlay which creates change. It's not overly difficult, but it does require a certain level of thinking it through. Now, looking towards the future, which is you're saying towards the end, as I end up here, I just wanted to think about, when I think I've gone longer than I expected, I apologize. I will go very quickly through this. You and I think of an Indian court and an American court. And there's a dispute, say, between an Indian party and an American party. Would it ever be possible that I bring a case at the U.S. District Court here in Toledo, you bring the same case at the district court in Gujarat, and because it's virtual, the judges there and the judges here actually hear the case together? Now, I know India has its procedures, the US has its procedures, India has its law, Ohio has its law, but the evidence that would be brought forward for both cases might be very similar. The same witnesses, the same documents, and all that stuff. And so all of a sudden, and I know time zone and all that stuff, but I've imagined in my head that it could be that you could have simultaneously two judgments in both countries come out of that same procedure. Now, I know that courts are jealous about their territoriality. What I'm talking about is just sort of just an imagining that this is something that we could maybe do with regards to the same case. And is that a good thing? I don't know. But it's something that I said, imagine instead of having to take an arbitration award and then take it to a court to get it enforced, you could have simultaneous judgments in two countries, or 3 countries or 5 countries, boom, in each one under the local system. Now, of course, you've got the appeals issue up there, but here's another one. There's usually a relationship between a court and an arbitral tribunal sometime. There'll be related court proceedings. Again, virtually, the judge in the court, the arbitrators in the arbitral tribunal, can they dialogue? Is that going to be permitted for them to dialogue with each other as part of the deliberations that are there? Should we allow that? Or how about you have an arbitration between party A and party B, like the owner and the general contractor, and there's arbitration between the general contractor and the subcontractor? Can that whole arbitration, the 2 different arbitrations, be brought together into one virtual space for purposes of what is in common, and then kept separately in breakout rooms for the parts that are different? We can do that with the technology, with the appropriate technology. I haven't spoken to things like artificial intelligence and the idea of are there ways of developing, for example, you want you're worried about some machine, and that in real time, as part of the procedure, a search can be done that brings up within, say, the judicial credible system, not like on Google or something, but brings up the relevant materials that have been already discussed on that topic in the legal system that's there, using sort of an artificial intelligence search kind of thing. And that could be brought in right away. Or if somebody, what I'm trying to help everyone who's listening dream is the possibilities that there may be there, just like the virtual law school has opened up a possibility that has not been seen before, and then is going to evolve into other things as it moves along. You see, it's that opening to what can we do, where at the same time also the technology is moving forward and the ability to do things, so that there's kind of this dynamic operating on the technology side, and that dynamic influences back to the dispute settlement side, and it's just kind of this back and forth, you'd say yin and yang kind of thing that maybe can happen. I've been speaking mainly on the private sector, on the private side. Now let's think about the public side, about legislatures. We talked about courts some, how the executive is. Technology comes into all these places. We can think in the international side, the international organizations, like the United Nations or UN Human Rights and all that. They've been forced to move to these virtual hearings and all that too. There's so much that's happened where all of a sudden you have to think about how to do it online. I'll finish with this warning, though. This is a true story. Indonesia was negotiating a big trade deal, I think, or had a trade dispute with the United States. And Indonesia, as they would do, as you would do if you're going to have a dispute with another country, you hire lawyers from that country who are very sophisticated. This firm in particular was called Meyer. So now you have this law firm called Meyer that is working with its Indonesian client and developing its strategies for its negotiation with the U.S. government. Australia has an agreement with the United States called the Five Eyes Agreement, which is Australia, New Zealand, Canada, and the United States for surveillance, intelligence surveillance all over the world. And so Australia's intelligence people pick up the conversations between the Indonesian government and their lawyer in America with their electronic technology. And that's what they do. And so now the Australians have this, and under the Five Eyes agreement, they agreed to all share whatever may be relevant for purposes in each of those countries, right? So the Australians say, hey, America, we have some stuff related to America here. And that's the other side in the negotiation. Now, the American government says, we didn't look at it. Okay, of course, what else are they going to say? I'm not going to say they did. I'm not going to say they didn't. I know that they're going to say, we didn't look at it. But it brought forth to me one thing, which is that in the intelligence areas, we talk about the privileges between the attorney and the client. The definitions in intelligence may not be the same as the ones that you see in the law. I think that the U.S. intelligence definition was, yes, the attorney-client privilege operates between an American counsel with a client in the physical United States. Well, that Indonesia is not within the physical United States. So then, that's fair game. But we would think in the physical world that, of course, the attorney-client privilege operates between the client and their lawyer wherever they are. Now, it's different where the lawyer is and what law applies, but whatever the dimensions of it, it is between the client and the lawyer, you see? And there's another thing that, I have to speak about, and I'm not being political here, but I do know that there was a judge who's trying to go virtually, right? And the advice at their court was, you can't use Zoom. I said, why? Because they're Chinese servers. I don't know if this is true. I don't know, but this is what was the advice, because they were worried about, you have some case, who cares? Really, it's not a big case or anything, but somehow it's on a server that they're worried about it being in China. You can go on a million ways. My personal thing is this. What about if there was intellectual property, special trade secrets, all that with regard to that machine that you wanted to have as part of the evidence in your online arbitration? Would you worry about this? About industrial espionage of certain kind? Or, national industrial espionage? Because they want to say, so that machine, it does this, it's a machine to make PPE that can make PPE instead of at $30,000 an hour, $300,000 an hour, in the pandemic. We would want to know how to do that, and you can't get a direct contact with the company. Well, with the intelligence services, with all the pressure on all the governments, be encouraged, find that out for us. You see what I'm saying? And they have an arbitration, I hear. Okay, well, we will get a feed into that. You may think that I'm crazy, but I went to Guantanamo as a human rights observer many years ago. And it was the 9/11 case with, Khalid Sheikh Mohammed and all the names that you've seen. And just to watch. And there was a court security officer and the judge. And if there was something that was confidential or, national security, there's a button they would press and a big red light would go off, and the feed that we would hear, the sound would cut and the feed would disappear. All right. So one of those boring, it's kind of a boring moment. One of the lawyers is talking. All of a sudden the light goes off and the feed cuts and the picture disappears. We're in a gallery behind a wall. But we can see into the room, like I can see you. And everyone's running around like chickens with their heads cut off about what's going on. So after about 15, 20 minutes, the feed comes back up, and the judge says, I did not cut the feed. The court security officer did not cut the feed. And so all of a sudden, everyone was like, well, who cut the feed? And the idea that there was another line into that whole thing from somewhere, probably the CIA, opened up a whole can of worms. Because when you turn off your mic, like I've been mute, I can press mute there. am I muted? That became an issue in the courtroom because they call about gated and ungated microphones. There was a overhead. There was in one of the rooms something that looked like a sprinkler. Turns out it wasn't a sprinkler. It was a listening device. You see, I mean, you can get into the craziness once you start talking about behind the national security veil. There's all these things that you have to think about. Now, guess what? In the physical world, same thing is true. But I just bring that up because of that Meyer Indonesia case, which, something that has to be thought about, because no institution, no law firm is going to be capable of battling against that kind of thing. And maybe sort of like one stream in the water you have to be aware of to try to protect yourself. But there, people use different technology. They can have all this could be encrypted and all that stuff. But, are there backdoors on encryption and all that stuff? Anyway, I stop at that point. But my feeling is that we're all humans. We're looking at the mix between technology and dispute methods. We have adapted for now, and we're doing the best to adapt in a terrible situation at this point. And hopefully it can also lead to creativity, particularly maybe some of the students that you have will see with their fresh eyes things that we don't see as us old grizzled people, to take it in places where it helps humanity progress in ways that helps people resolve peacefully their disputes. Right? I think I would stop there and welcome any questions. Yeah.
Right. Thank you, Ben. It was a very interesting lecture because while you were speaking, at least I could take down a lot of notes, for myself. So, yeah. So now, before there are few students who may want to ask questions, a couple of my colleagues and friends who may want to ask questions. So I would request everybody to keep your questions ready. Probably you can type out in the chat box or Q&A section. Or if you want, you could, use the button to raise your hand, and I can unmute you, and then you can, directly have a conversation with Ben here. So, I mean, by the time you all figure out your questions, I have a few observations and questions that I want to share with Ben. Now, when we were discussing about the topic for your lecture today. So we tried to ourselves go back and forth, figure out that what would be a better way of putting forth the topic, which can cover different kind of aspects together. Now, when I was looking at the topic and trying to analyze it from different angles, and I tell you, since last 6 months, we all in our respective jurisdictions, we are aware about how the courts are working. Probably if some of us who have been rubbing our shoulders with the mediators or arbitrators, so we would know actually what is happening actually with regard to the mediation or the arbitration, especially in the online regime. Now, in this regard, one of the issues, rather few of the issues which I could see from your lecture, surfacing very importantly for the purpose of legal research, as well as for the purpose of finding the future answers is, one, that probably you will agree, and I wanted to know it from you, that what is your experience in the US, that by virtue of the online system that we all are compelled to use now, isn't it that the arbitration as well as the mediation have undergone a little kind of a slow pace, as probably they were expected to be very fast-paced dispute settlement mechanisms, especially in contrast to the regular courts in whichever country, it doesn't matter. To the best of my understanding, in most of the common law countries, majority of the courts have their own set of respective issues to deal with, and they also take longer than the regular mediation or arbitration, right? So isn't it that the online system has actually reduced or has downgraded that kind of a pace of the mediation and arbitration? One. Second thing, would you probably agree, by virtue of your experience, that in the online regime, as I probably see as a law teacher of mediation and arbitration, or ADR, that now the mediation can rather pick up first as opposed to arbitration for the less procedural aspects involved in mediation. And by virtue of that, in the online system, there appears probably, I'm adding that very carefully, probably there appears to be less risk in the online mediation. Now, why I say that, I'm basing my argument on the reason that a couple of days ago, I was speaking to one of the former judges of the Supreme Court here, who does a lot of arbitration work. So I was discussing, with the judge that how is arbitration going on going forward. So he mentioned and shared with me that when it comes to the regular general, hearings, so things are going on. The parties are coming forward. The arbitrators, as you have mentioned, be from whichever jurisdiction, even in India, if they are from 2 or 3 different states, they, come online. But when it comes to the recording of the evidence, then it's not taking place, right? So there's a glitch. There's a problem. That's
Yeah,
that's an area which cannot be taken up so easily in the virtual mechanism, even in the arbitration world. One next thing what I want to mention is that when you or maybe you can answer this first, your reflection, then I can share some of the other issues. Then what do you
okay.
think?
So I think that I would say that there are a couple thoughts that come to mind. One is uh, the slowing down. Okay, the slowing down of the relative court to arbitration mediation. That's probably true because um, first there is the enormous adaptation that everyone has had to go through. It used to be that you had your secretary was out in front of your office and all that. Your secretary's at home now. Your files, they're over here. Your files, you're at home. Your files are down at the office. I mean, so I think that just physically there's been sort of virtualizing of relationships and having to adapt them to this new reality in terms of access to information to do what you do for purposes of an argument or anything. So that's what we've been going through. And so addressing those new ways of interacting takes time. And this is independent of the actual case. It's just the physical task of figuring out or organizing how you work in this environment. So yes, I think that is slowed down because we're all learning. It's the old famous learning curve or experience curve. We're up at the top. And we're just trying, and some of us are going down faster, some are going slower. I've talked with the technology person for the National Center for State Courts here in the United States. And the adaptation to this environment has gone quicker at the courts that had, guess what, been open to technology beforehand. And the adaptation has gone slower, guess what, at the courts that hadn't started down that path already, right? So law firms that have been open to technology probably have done it faster. Law firms that have kept technology more minimum, they're having to address it. Clients, business clients, each one of those dynamics are operating differently. And so you add that all up, and I say, yes, more time, because all of a sudden everybody is running down this hill. Some are fast, some are a little slower, some don't even have shoes to run in, right? You see what I'm saying?
Right.
And so yes, I personally do hope, obviously, that this like we all do, we hope that the COVID disappears. But there is a hope also that once it's disappeared, what we've learned from this and the changes that it has may show us ways to do things quicker. So we're in the slow beginning phase and then on to there. On your second question, which is about the glitch, if we could call it like that, absolutely. And that glitch can affect the enforceability of an arbitral award, or whether somebody meets their burden of proof before a judge, all kinds of things like that. And figuring out how to manage that is absolutely crucial. Absolutely crucial. Is every session recorded? Now you have to store it somewhere. Where is your store? I mean, this be, it has to be thought through so that there is no question that what was supposed to be kept for an appeal or an attack against an award is kept. Now, the relative arbitration versus mediation and mediation advantage. The thing that's nice about mediation is that it's non-adjudicatory, right? So although you can have a kind of very tough adjudicatory kind of mediator, right? But you're getting to a settlement. And what is a settlement? Ultimately, it's a consent, right? It's consent. Parties agree to deal with the matter that way, as opposed to the arbitration where you're having the judgment, unless you have an award on agreed terms, of somebody on the outside. And so the due process rules, if there are any, are much more flexible with regards to basically, did you settle or not? If you did settle, great. If you didn't, okay. And then settlement, it gets you back to contract, in mediation. And then there's the 8 ways to avoid enforcement of a contract kinds of things with, was there fraud in the inducement? All those kind of things to attack the settlement. But it's different from an award. So issues that can further complicate for arbitration is, say you have 2 defendants or 2 respondents in the arbitration, one participates, the other doesn't. How do you go ahead and do the steps that will say that the award will be enforceable against the second one who is not participating? How do you make sure you protect their due process rights as you go forward about notice of hearings, deadlines to speak, deadlines for submissions, proof of all those things? The arbitral institution's rules may help you, absolutely, with regard to that, but they're always thinking about that, am I going to be will the party who wins, whatever I decide, be seeking to enforce this award over there? And over there, are they friendly to this online stuff, or are they unfriendly in that country over there? Oh, you just have to, as the arbitrator, once you don't have consent, one thing that can be interesting is whether there's a flexibility in the rules that doesn't require consent. It says something like the arbitrator takes into account any submissions of the parties and then determines the procedure that it considers appropriate, or something like that. Maybe that opens up the space for doing an online hearing or not. But I do know of a case early on in the pandemic where an arbitrator, because of the switch, said, okay, let's do the hearing virtually. It's in a domestic arbitration. And the respondent said, no, I don't agree to doing a domestic, this is not a hearing. And the arbitrator, really had to think about how to figure that out, whether under the law that could potentially be applicable, he would be on safe ground to go ahead with the virtual hearing or not. That's part of the transition that's happened there, and that's where mediation would have make it much more easy. Those are the kind of things that I would think about with regards to that. I hope that answers your questions.
Right. Yeah, perfect. Thank you, Ben. So we have a few questions coming up from students. What I'll do is I'll allow them to use the mic, because I personally believe that enhances the level of discussion in the online classes and the forum, right? And that's how everybody gets to participate in a better way. So, Dana, can I first of all do it for you? I'm going to unmute you. You can go ahead, introduce yourself, and then ask questions.
Hello, am I audible?
Yeah, please introduce yourself. You're audible. Good. Go ahead.
Hi, my name is Diana Ibarra. I'm coming from Amity Law School. and I'm in my first semester of my BA LLB honors course.
Yes.
So
Yay!
yes. So I'm actually currently in Saudi Arabia, so my accent is going to switch between Indian and like. Sorry, not important to the question. Sorry, let me just collect myself. I
You're fine.
apologize.
Relax, relax. It's okay.
I just want to say your discussion was very informative and very insightful. So thank you for that. And my question is, do you think that there are any, do you think that some of the dispute resolution techniques that have developed during the pandemic could or should be continued when the world opens back up again?
Thank you very much for that, and congratulations on your studies. And my view is that this is an opportunity for new thought, new ideas to develop, constrained by, what is it? Necessity is the mother of invention. Well, we are in necessity, and the mother of invention has developed all these inventions. And I do think that, yes, there are aspects of this, and they are changing things. I can't speak specifically. I'm not going to speak specifically to dispute settlement, but for example, this past spring, the American Bar Association section of dispute resolution, you had its spring conference scheduled for April. COVID all of a sudden made it impossible to have a meeting of 600, 700 people. I think that, in fact, one of the big super spreader moments was somewhere in a meeting in Singapore early on of a lot of specialists. So they had to redo the entire conference into a virtual conference. And one of the things that happened with that experience is that the cost structure for doing a conference was dramatically less. And so all of a sudden, you start to say, well, do we really have to go to a town and have the hotel and the travel and all that stuff to do for 1 or 2 days? Or can we maybe just keep doing things this way? One of the things that I found for myself personally is I'm up here in the third floor of my house, which Nashikita has visited, and I'm now in India. I have not had to get on a plane. I'm in Saudi Arabia. Here I am too, And a couple of days ago, I was in Hawaii. A couple of days ago, a couple of days coming, I'll be in Germany, Switzerland, and Vermont. And I haven't moved from my bedroom. And I find myself actually being more amenable to speak on topics because the whole burden of the travel is reduced. And if I'm feeling that way, I think that the idea for exchanges of ideas and exchanges are accelerated, because certainly this has been a case with, I think, some companies like Microsoft and Google, where they have teams working all over the world 24/7, and they don't fly people to the offices of the team. They're all on this WebEx, or they're on Presence or something, all these different technologies to create virtual meeting rooms almost, where everyone is from around the world working. And really, the question, they're both closer and separate in the sense that they're not seeing each other physically together and having coffee or something like that. All those informal things are not built into it. But yeah, I would say yes, and I hope so. In the way, I don't know, but yes, because it has got this opportunity to accelerate contact. I hope that answers your question.
Yes, it does. Thank you very much.
Right.
All right. Have a good day.
Yeah. Thank you, Ben. So, Ben, we have another question from Mr. Kumar. I'm going to unmute you, Mr. Kumar, so you can use your mic and speak up.
Yeah, good morning, Mr. Benjamin. This
Hello.
is Kumar. Yeah, this is Kumar from Amity Law School, Mumbai. I have a simple question. Is there any reference case for international arbitration resolution in the virtual court? I personally believe COVID-19 has forced everyone to inculcate new way of working, which is very cost effective, very convenient, and also helping nature by reducing the emission due to international travel. Maybe
Yes.
airlines will lose the business, but for this to happen effectively, we may have to write some of the laws, amend the laws, and also set up a procedure and the documentation how virtual arbitration or even virtual trial should be conducted. I think as a law or as a mandatory, this should be encouraged not only for international arbitration resolution, even for a domestic, because it brings down the infrastructural load of travel, pain, energy, and emission.
Yes.
So this is my point, is anyone is working on this to develop the proper procedure, making it acceptable by everybody, so that we prove this is more efficient in terms of effectiveness, and the cost efficiency is very high. Yeah, this is
Right.
my opinion.
Yes. And I think, and I agree with your opinion. And the answer that I can give is that I am aware of different entities that are working on both the technology side and the law side, so to speak. I suspect that everywhere in the world right now that is going on. I want to just start, but I'm not aware of all the places. So one place for arbitration is, I know that what is called the International Council on Commercial Arbitration has a project looking forward on the issue of what is a hearing. Okay, trying to think about, I think, what this online hearing is. I also thought that there were a number of arbitral institutions that put out advice very soon after the pandemic started about how you can do things virtually in your arbitration. So you see sort of the organic entities on the front lines trying to bridge the technology gap in the context of the basic legal regimes that people are dealing with. In the States, actually worldwide, there is the National Center for Technology and Dispute Resolution at the University of Massachusetts. Their website is odr.info, and I'm one of the fellows there. And they've been working on online dispute resolution for 25 years. And they have publications, they have efforts to develop a dispute resolution, and in the environments that are going on really all over the world. And some of the participants and fellows in that are from India. I'm thinking of, there's a person called Chitu Najaran, who has been very involved with the developments there over these past years. So that's another space. There's the National Center for State Courts in the United States, which has been working very hard on bringing technology into the courtrooms, into common law courts, right? Then, of course, they're also in England. I'm aware of efforts. One of the nice things about this National Center for Technology and Dispute Resolution is that you have members who are coming from all over the world. And so they are, in a way, your way into what's going on in New Zealand, or what's going on in Australia, or wherever. Like there's a guy named Alberto Elizavetsky, who is from Argentina, and he has been working on ODR Latino America for 20 odd years. And the things that he is doing in Latin America and his interactions and his work with the courts in Latin America are just astounding. So yes, there are these places, you know, I will sound biased, I know, but I really do believe that the National Center for Technology and Dispute Resolution that is at the University of Massachusetts, which is focused worldwide and has members worldwide, and been working on this for 20, 25 years, is a good place to start to get the information to then move on from there to developments of law and all that. There is an article coming out from a professor named Amy Schmitz, that's SCHMITZ, I think it's at Fordham Law School, where she speaks specifically to some of the issues of online arbitration. In fact, she coins, I think, the phrase OARB as a whole new kind of concept that that we should give her credit for, and that's what I feel is in the background of my discussion, where she kind of looks through the jurisprudence to see what kinds of issues have happened. I do know, for example, it's always tied to the local law. Like in the United States, the Federal Arbitration Act, they talk about a witness appearing for the arbitrator. Well, then the question becomes, what does before the arbitrator mean in a virtual setting? Is it the physical, like before, or can we think of it also as being this virtual before? Those kinds of issues. And it's a very interesting piece. I think she has it up at ssrn.com. It's unpublished yet, so it's not for citing, but it speaks to a lot of the issues that I hope to be of assistance to you, Mr. Kumar.
Yeah, okay. I have a small extension. Do you think this legal community will resist for virtual court resolutions because of whatever reasons? I feel, at least in India, there could be some resistance. I see resistance in the universities for online teaching because they think it is not effective. But I expect the same kind of resistance from the legal community for virtual courts. What is your opinion?
So, yeah, I guess the way I guess the way I see it is, and I'll speak to both aspects of it. People are comfortable with what they do. When I first, for example, I worked at the International Chamber of Commerce in Paris, right? And when I first got there in 1986, the only person who had a computer on their desk was the secretary, because counsels do not have computers on their desk. It is not done. And when there was the idea of putting computers now on the assistant as well as the secretary's desk, well, that's okay. But counsels do not have computers. And then when they wanted to put computers on counsel's desk, well, there's a little discussion, but counsels finally go along with it. All right. So that's what I'm talking about, is sort of a culture of work that you've developed, a way of working that each of these places, each of these law firms has. And now you're having that come up against this digital technology machine. I don't know how to even describe tsunami, I would say, or typhoon, and there is a certain level of resistance that I can totally understand. It is different to be together, it's different to be getting a coffee together and talking and going to a restaurant and sitting down and all those things of being together. It is different. It absolutely is. And the question is, we can't mimic it, but can we get close enough to it and take advantage of all those advantages that you outline? the funny thing for me, at least I went through the process of developing the first case management online the technology internally for the ICC court back in 1989, 1993. And one of the things that I found was that the more experienced people were actually more open because they had a certain level of security in their capacity to do on the substance of what they were doing. They knew the nuances of what their work was and the issues that were there. So they were actually more open to the technology because the technology didn't cause fear for them. It was just something they had to learn to adapt to. But the younger people actually, in a way, were more reticent because they're so insecure about their capacity to address the subject matter that had to be there. That they learned one way to do it, and that way. And so the older people said, well, there are many different ways to make things happen, and they're more flexible, you see. I would just speak to the virtual teaching. I've taught since March in virtually, and I basically created, on the fly quickly my second half of my semester. But then I took an online teacher training class that led me to change radically the way I taught my actual summer class in international law. And I'm actually now doing a further online course design certificate to learn. You see, this is me going back to school. Again, going back to school to learn from people who do these design things, how to do the, to use this environment in this new way, you see? So that's what I think we're all going through, and I think that there will be resistance, but the tsunami is coming. The typhoon is. We are in the pandemic. And we're forced to do some path on that, even if we don't want to, and even if we're reluctant, we're just forced to.
Right.
Yeah.
Thank you.
Small question. This is the last question, I promise.
No problem. Please go ahead.
I am of the opinion that a computer.
I have great respect for Indian lawyers. I love Indian lawyers, brother.
Yeah.
I had many cases with Indian lawyers when I worked at the ICC, and I've said many years, I love Indian lawyers. I've had some Indian lawyer students here at Toledo too, and it's like, you guys are great, man. All right, yeah.
Thank you very much. Okay, my point is, computer-aided adjudication process, especially using the artificial intelligence technologies for evidence collection and proving, doing lot of back-end office and virtual code can definitely give a big value addition, provided every stakeholder starts believing and developing and taking the leverage of the available tools. Is it happening in the US?
Yes, there are a number of startups that I've seen. The American Bar Association section of dispute resolution had an Expo Tech in September, and so there were a number of the tech entities that were showing off their different technology offerings, if I could say that. There was an effort to create a virtual court a while back up in Michigan. That was, say, 20 years ago. And everyone was sort of like, oh, the cyber court, and it was all, but, it was a little ahead of its time. I think now, with everything that's going on, it may be the right time for those kinds of things to be developed. As to the artificial intelligence and algorithms and all this, I want to say one thing that I love, that I learned from somebody else. We must have technology, but we cannot have tricknology. Okay? Because these algorithms have impact. in terms of, sometimes they can be devastating impact. For example, you get into this idea of sort of predictive technologies, right? And, somebody it's happened in courts in some places in the United States, is some kind of quote unquote predictive technology gives some person who is being convicted of a crime a number. There are 3. Well, 3 means that they're likely to commit a crime again. Now, what's that based on? They live in a certain area, right? They have a certain income, right? Okay, all those things may be true, but why does that predict that there's a lot of crime in that area for people with that kind of income. Therefore, this person is more of a risk than this person who lives in another area. You see that kind of algorithm logic, which is impeccable, but it completely runs the problem of correlation versus causation, right? I mean, and so that's why, but unfortunately, when somebody says, there's some report that comes up and it says this person is a 3, we have this talismanic vision of the number that makes us think that that is truth, when underneath it, the algorithm may have just gone off the rails. So that's why I say technology great, but not technology. And that is really a powerful thought somebody said to me that really helped. The guy who said it, actually, I don't know if you heard about the Central Park 5 in the United States, those 5 young men who were convicted of a rape, and it turned out that they were acquitted 20 years later. Well, one of those guys went on to become a doctor and a PhD and all that, and he came to speak here in Toledo. And that's where I heard it. Technology, not trick. I think that if he had been staying in jail the last 20 years, that idea would have never come to me. And the effort of the lawyers really helped to make it possible for his brilliance to grow, you see?
Right.
Okay. Thank you very much.
Thank you, Mr. Kumar, for asking the questions. And so thank you, Ben. It was very patient of you to answer all these questions. And I must tell you, that for example, we recently got 2 of our students going for internship with Chitu Natarajan you were talking about. So,
great!
Yes,
Great!
right,
Yes!
Right. Ever since I started the virtual law school, so I was looking for different kind of trying to reach out to a lot of my law firm friends and lawyers. So in that process, I could also get in touch with Chitu Natarajan, and that's how a couple of my students from virtual law school, who are for the purpose of degree, the students of some other law school, but they attending classes of law in the virtual law school. So I got them placed for the online dispute resolution related internship in Chitu's firm.
You are with the number 1. She's right at the top. I mean, they cannot do better. She's been at it for so long and cannot do better. So super.
Right. So
everybody out there, we did not know this. We did not organize this. This was independently confirmation. That's one.
Yeah, and that happens with you and me all the time. We develop so many of mutual connections that we have done. Number of times from Atlanta to Toledo to India.
Yes.
So thank you, Ben, today for coming online and sharing your thoughts on mediation and arbitration. And my reason was definitely to bring you on board, because as per my knowledge that you've been doing so much of work in this particular field of law, and as part of your teaching, research, and as well as your long career and experience in ICC in Paris. So I am sure that there are going to be further challenges probably in the times to come, because as we were talking about, as you shared your thought process, that it's just a beginning, right? And we all are adapting to the new ways of settling disputes in mediation and in arbitration. As I could bring forward, some of the aspects with regard to glitches and technical problems with regard, for the purpose of evidence recording. So given all of that, I'm sure that we have made a sort of already a beginning in that sense in every jurisdiction. It's not just about India, US, or whichever, right? So as Mr. Kumar was talking about, I think a short answer can also be that it's not about that whether one kind of a legal community or lawyers or teachers would not welcome it, but we are posed with a compelling situation. There's no option as we see that. right? So it's
Yeah.
kind of a necessity. And even when I see it from the lawyer's point of view, even for the purpose of, that they have to earn the living, right? So
Yeah.
and they cannot do anything by virtue of saying that, probably we cannot go for online legal education or online courts. We all are part of the process, and I believe collectively we can combat it, and we can
Yeah.
all contribute with newer ideas collectively only. Right.
Agreed.
So,
Agreed. Absolutely.
in fact, I'm looking forward. I tell you, Ben, as part of my ADR and mediation classes that we started in June. So I'm trying to look at that how we can do a demo mediation or a mock mediation sessions in the
Sure.
breakout sessions. And I'm aware that some of the competitions are already being held in that way. So it's not something which is impossible. It's certainly a possibility. Only thing is that we need to have a system, for example, whether Zoom allows you or WebEx allows you or Microsoft Team allows you. So you need to pick the right software. It's like picking up the
Right.
right kind of facility, which
Right.
which I think happens even in the physical format when we go to one arbitration center or the other one. Right.
Yeah.
So it's about picking up your choices, and it's
Right.
pretty much doable. For example, I tell you, I was attending on on mediation and things like that in Miami-Dade College online. That was online during this time of pandemic from India. So I could see that it was working out well even there, where I and the professor could visit the different online rooms,
Yes.
to hear the conversations of the one set of students. Then we withdrew from there online and joined the another online room,
Yeah.
and
Yeah.
on our screen they all were visible alike together.
Yes. Yes.
So
Yes.
there's been a lot of innovative possibilities, and we have been all exploring as the law teachers, lawyers, judges, in every sense of a community. So I think it's going to rather unfold and also get consolidated in the years to come.
Yes, and I want to encourage. I'm always there's that thing in business, first mover advantage. Okay,
Right.
I mean Microsoft, Google. You can think of it, Amazon. First mover advantage is like you go down that learning curve, that experience curve.
Right.
The quicker you go down it, the quicker you get to amazing things. So
True. Right. Right. So thank you once again. It was a wonderful session, learning insights for me, for my students, colleagues, lawyers, everybody here in India who were wanting to interact with you, and some of them who could, speak out and talk to you today. So I hope everything well at your end, and
I am doing very well. I want to say to you that while we were talking, up popped on my screen an email from the president of our International Law Society here.
Mhm.
So I am going to talk to her to ask her if she would permit me to ask you to come and do a seminar for them at the law school here. We'll do it virtually like this too.
Right.
And I should talk about that online, but I hope that we can continue this because you're doing great
Indeed,
stuff,
that
brother.
would be a pleasure to speak to your students. And I've been doing something since 2014, right? So your Society of International Law has been very
Yes.
generous, to host me since 2014
Yes.
till date. So I would love
Yeah.
to do that again. Yeah.
All right, wonderful, brother. I'll be back in touch with you about that in due course, okay?
Sure. Yeah. Thank you, Ben. Goodbye. Take care.
All right. All good things to everyone. Stay safe.